Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to this October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On January 11th, the court heard argument in a pair of immigration cases, Johnson v. Arteaga-Martinez and Garland v. Gonzalez. Joining today to discuss this decision in two parts is Professor Ilya Somin, Professor of Law at George Mason's Antonin Scalia Law School. The episode will begin with coverage of question and background, and proceed in second part to focused analysis of oral argument.
The two cases are Johnson versus Arteaga-Martinez, which comes from the Third Circuit, and the second one is Garland versus Gonzalez, which comes from the Ninth Circuit. In the case of the Third Circuit decision, what is really being reviewed is not Johnson versus Arteaga-Martinez itself, but rather an earlier case decided previously in 3 years ago, where called Guerrero-Sanchez versus York County Prison, because the more recent Third Circuit decision simply relies on the 2018 decision. It's just a couple sentence order, which, as everybody agrees, that the 2018 decision controls this one. So somewhat confusingly, the real Third Circuit decision being reviewed is not the one that's officially being reviewed. And both of these decisions deal with detention under a statute called 8 U.S.C. Section 1231, which states that the Attorney General shall remove an alien from the United States within a period of 90 days when an alien is ordered removed for certain reasons, but also states that the alien who's ordered removed may be detained beyond the removal period in certain circumstances. It does not specifically say whether the people being detained in this way are entitled to a bond hearing to determine whether they should be released as opposed to be detained, released on bond, but it does contemplate the possibility that they may be released, and if they are released, then they're subject to certain terms of supervision, which is in another provision of 8 U.S.C. Section 1231. So the question is whether people detained under this statute have the right to seek a bond hearing in which the government would have to prove that they're dangerous or a threat to the community or the like before being able to continue to detain them. If they can't prove that, then they could be released on bond. And both the Third Circuit and the Ninth Circuit concluded that there is, in fact, a right to this bond hearing. If the person has been detained much longer than the removal period, they concluded that this is 180 days. And you might ask, why are people detained longer than the time during which, in principle, they're supposed to be removed? It's because many of the people detained actually have legal challenges to their removal, which they're pursuing, and the nature of the immigration court system is that often such challenges take many months, in some cases even years, to adjudicate. So these people are pursuing legal rights that they have to challenge their detention and removal, but the resolution of those challenges can take a long time because of the structure of the system. There are a number of technical issues also at stake in these cases, which I'm skipping over, partly for considerations of time and partly because I don't want to bore people people too much. For example, the Ninth Circuit is under the actually a preliminary injunction, so there are some issues there whether certain preliminary injunction standards have been met. But the core issue is whether the government can detain these people indefinitely without giving them a bond hearing. And both the Third Circuit and the Ninth Circuit said that the statute is sufficiently ambiguous on whether it requires such a bond hearing or not, that the canon of constitutional avoidance applies. What is the canon of constitutional avoidance? It is a long-standing rule of statutory interpretation, which says that if a statute is ambiguous, then if at all possible, courts should interpret it to avoid constitutional problems if there is an interpretation which avoids them. And in a case called Zedvitas in 2001, the Supreme Court ruled correctly, I think, that indefinite detention for an alien where it's not clear whether they actually will be removed or not, such indefinite detention at the very least raises serious constitutional problems under the Due Process Clause of the Fifth Amendment, which among other things says that you cannot be detained without due process of law. And in this case, they're detaining people who haven't been convicted of anything, or at least are not being detained for the thing they were convicted for. And also often the detention itself happens with very little due process of any kind. One of notorious aspects of the immigration system is that people are detained often with very little due process. There's not a right to counsel in these hearings. There's little consideration of evidence and so on. So the government is arguing that there is no constitutional problem here, and that the statute isn't ambiguous, and they're particularly relying on a decision called Jennings versus Rodriguez, decided in 2018 by the Supreme Court, which, among other things, reversed some previous Ninth Circuit decisions, which had required a bond hearing, not under Section 1231, but under Sections 1225 and 1226 of the same part of the U.S. Code. And they say, well, if there's no right to a bond hearing under those statutes, then it's clearly the case that there's no right under this one either. But the Third Circuit, I think, quite properly said there's a big difference between 1225 and 1226 on the one hand and 1231 on the other. And specifically 1225 and 26 both say that the government, quote, shall detain the non-citizens in question. On the other hand, Section 1231 says merely that they may detain them and also contemplates possible release. I think this is a major textual distinction between these sections, and I think good reason to say that Jennings does not apply to Section 1231. The Supreme Court can, of course, decide that it does apply. They can do whatever they want, almost, but at least there is this very crucial textual distinction. And as I said before, the normal rule for the constitutional avoidance canon is that if it is at all possible to come up with a plausible interpretation of an ambiguous statute that doesn't raise constitutional problems, courts are required to pick that approach as opposed to one where there is constitutional problems. The Supreme Court, including in the famous case of NFIB versus Sibelius, actually said that when there's two plausible interpretations, the courts even are supposed to choose the less plausible of the two if that one avoids constitutional problems, so long as the less plausible one is at least somewhat minimally reasonably plausible. Now, there obviously are people who criticize that canon, and I'm not going to try to get into that debate here. I will merely say that so long as that canon remains in place, it should be applied to immigration law no less than to any other area of law. And if it is applied to immigration law in the same way, then I think the Third Circuit decisions and the Ninth Circuit decisions should be upheld. And this gets us to the general issues at stake in these cases, which go beyond the the specific details. One is the extent to which this will be another case where there could be a double standard between the way rules of constitutional law and statutory interpretation are applied everywhere else and the way that they're applied to immigration law. There's a wide range of areas where the Supreme Court essentially held that normal constitutional constraints on government power do not apply, either do not apply at all or do not apply with the same force to immigration restrictions. The Trump travel ban case from 2018 is the most famous recent decision like this, but there are others. And sadly, I think it's possible that this will be another case like that where they'll say that essentially the constitutional avoidance canon doesn't apply in this context to the same degree, or alternatively, maybe even the due process clause of the Fifth Amendment, which limits prolonged detention, maybe that doesn't apply in the same way. So I think there is a risk that that will happen, even though there is no textual or originalist basis for saying that immigration law is special in this way. For those who are interested, I published an article in The Atlantic going over these broader issues in greater detail back in 2019. I'm happy to talk about it in questions further, but I can't fully lay it out here. The second broader issue here is the general problem, which is not solely limited to immigration law, of detention without conviction or without much due process. This exists in other aspects of the criminal justice system, like with pretrial detention, but with immigration law, it's even worse in that people are detained for long periods of time with very little due process. In the Guerrero-Sanchez case, which is the 2018 Third Circuit decision under review here, the person in question been detained for 637 days without any kind of hearing before the Third Circuit decided the case. And such prolonged detention with little or no due process, sadly, is not unusual in the immigration system. Similar problems exist in other contexts in the justice system, but the immigration system is perhaps the single most egregious offender. And I think this kind of prolonged detention with very little due process is something that should trouble people, regardless of how they feel about immigration law generally or criminal justice generally, that it's very easy to seriously harm people in this way. In the immigration detention system, data suggests that every year we detain hundreds or even thousands of actual US citizens because there's so little due process that often the relevant government agencies don't figure out that the people are US citizens until they've been in detention for hundreds of days, or in some cases until they've even been deported to Central America or elsewhere. So what will the court do? I don't know for sure. I think, however, there is a good likelihood they will overrule the Third Circuit and the Ninth Circuit. I think that for two reasons. One is when the Ninth Circuit case sends a case up to the Supreme Court, it's always or very often very likely they'll get overruled. The second is, sadly, I think many, if not all, of the conservative justices on the Supreme Court do accept the idea that there should be a double standard for immigration law, even though that double standard is not justified by the interpretive methodologies that they adopt in other cases. But I'm not far from completely certain about this prediction. I very much hope I'm wrong. Please, Supreme Court, prove me wrong on this. And there is a chance that the Supreme Court has really taken these cases because they think there is a circuit split. There is a Sixth Circuit decision called Hamani versus Aducci, which, depending on how you interpret it, could be seen as interpreting Section 1231A6 in a different way from the Third and the Ninth Circuit. But that decision only gives a very cursory treatment of the issue, and it's not easy to interpret.
Thank you to Professor Somin for joining today for this episode of SCOTUScast. As you all just heard in his prior remarks, Professor Somin provided a bit of overview, background, and some early predictions of the cases prior to argument. Today, with the benefit of these cases having been heard before the court, we will focus in this segment on a more narrow analysis of oral argument. Professor Somin, welcome.
Thank you so much for having me.
So could you please walk the listeners through oral argument in these cases, noting central questions, but also focusing in large part on how the justices grappled with them?
Sure. So the key question in both of these cases is whether there comes a point at which the statute should be interpreted to require the government to hold a bond hearing where the government would have to accept the release of these inmates upon, not inmates, detainees, upon conditions, unless the government can prove that they're somehow dangerous to the community or pose some sort of a threat. And both the Third Circuit and the Ninth Circuit actually had ruled that after approximately 6 months, if the person was still in detention, they are entitled to be released, or to a bond hearing rather, where the government would bear the burden of proof, because otherwise there would be serious constitutional problems, because indefinite detention without any kind of conviction or due process is a very serious constitutional violation, and therefore the canon of avoiding constitutional problems kicks in. Both the Third and the Ninth Circuit ruled that, in that the Supreme Court has repeatedly said that if you have an ambiguous federal statute and one of the possible interpretations raises constitutional problems, then courts have to prefer the other one, so long as the other one is even fairly minimally plausible. NFIB versus Sebelius, the Obamacare case from 2012, is one of the most famous examples of this canon being applied. So the Supreme Court held oral arguments in both of these cases. And as I explained in my previous talk on this in the Fed Talk podcast, these cases raise important issues, both about immigration in the Constitution and about the problem of detention without due process more generally. And if the government were to be permitted to detain people indefinitely in this way, either it would set a dangerous precedent for indefinite detention more generally, or at least one limited to the immigration system. It would reinforce the problem that we have double standards, where practices that would be widely seen as unconstitutional in virtually any other context are allowed in the context of immigration enforcement, to the point where there's so little due process and immigration detention that even large numbers of U.S. citizens end up being detained, and in some cases deported, because it takes a long time sometimes for the government to figure out that they even are U.S. citizens in the first place, because there's so little due process and safeguards in the system. So my expectation, as I said in the last podcast, was that most likely the Supreme Court would overrule the Third and the Ninth Circuit, even though I don't think that would be the right decision. I base that on two reasons. One is, in general, the Supreme Court is more likely to hear cases to overrule them than to uphold them. And that's especially true when one of the cases comes from the Ninth Circuit, which is notorious for being overruled all the time by the Supreme Court. Secondly, many, if not all, of the justices in the conservative majority do, in fact, sadly, in my view, accept the idea of an immigration double standard, that sort of constitutional standards that apply everywhere else often don't apply to immigration policy. However, after the oral argument, I'm not any longer at all confident that that prediction is right. And I will actually be happy if my prediction turns out to be wrong in that point. But I also honestly don't know which way it's going to go. So if you look at the oral argument, I think the three liberal justices, at least for the most part, as I would have expected, they're likely to uphold the Ninth Circuit and Third Circuit decisions, though Justice Kagan in particular did ask some tough questions for both sides. I think on the side of the conservative justices, to my mind, the signals are very mixed. Both Justice Barrett and also Justice Gorsuch actually expressed some sympathy with the arguments raised by the plaintiffs, that is the detainees in these cases. And Gorsuch even at one point said that the argument that there can't be indefinite detention in such cases, he said, quoted, "This resonates with me." Barrett raised some of these concerns as well. And some of the other conservative justices were more hostile to the detainees, but also most of those other justices actually didn't say that much in the oral argument, so their positions are hard to interpret. On the other hand, Gorsuch, and to some extent also Barrett, I think as well, suggested, especially Gorsuch at one point, that maybe the real argument the detainees should be making is not that the statute here should be interpreted to avoid constitutional problems, but that the indefinite detention is just simply unconstitutional straight out. Gorsuch may not think that there's sort of the statute is ambiguous enough to allow the canon of avoiding constitutional problems to kick in. So it's possible that you might get a decision where some of the conservative justices just simply agree with the government's position that all of this is constitutional and fine, but others might say, well, maybe it's not constitutional, but the issue of constitutionality is not before them right now, only the issue of avoiding constitutional problems, and therefore they're going to rule against the detainees. In one of the cases, there is also the issue that the named plaintiff is actually not in detention right now anyway, and it doesn't. There's an indication that the government will try to put him back into detention. So it could be argued that that case is moot, or should be dismissed on the basis that there's no longer really a live issue. There are. In the Ninth Circuit case, the Ninth Circuit case avoids that, but there might be some issues there with class certification and the like. So after listening to the oral argument, I was less pessimistic from my point of view than before, but also more confused as to exactly what might happen in these cases. And I think a number of different outcomes are possible. I'm not entirely sure by any means where certain conservative justices are going to vote. And I will note that in the case of Gorsuch, he has in a couple of other high-profile cases, sided with immigrants, including undocumented immigrants, against the government. Sessions versus Pereira is a famous example. There's also the famous case from when he was a 10th Circuit judge. The case where he argued against Chevron deference was actually a case involving an immigrant challenging the government. So it's not completely impossible that he might go that way. And perhaps also with Barrett, we simply don't know that much about her attitudes on these kinds of issues as compared with some of the other justices. On the other hand, Gorsuch did clearly endorse the double standard in immigration law in the travel ban case in 2018. So I'm not sure I fully understand Gorsuch's thinking on some of these issues. And more generally, I'm not sure where some of the conservative justices will come down here. This is perhaps the rare case where after oral argument, it seems more difficult to predict what might happen than before.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.